Our next speaker is Mr. Kenneth Standard, advogado, membro do Conselho de Governadores da American Bar Association e antigo presidente da New York State Bar Association, aliás, que é a ordem dos advogados norte-americana, que mais advogados têm inscritos, cerca de 70 mil advogados. Kenneth, if you please. Thank you.
Good afternoon. Thank you all for coming. Thank you for the kind introduction, and thank you for inviting me to return to Lisbon following my visit of last fall. Before I discuss my formal remarks with you, I just want to talk to you a little bit about how the regulation of lawyers differs in the United States from Portugal and most other countries in the world. The U.S. is a federal system, and under that system, each of our 50 states, as well as our capital district, Washington, D.C., each of those entities regulates the practice of law, the practice of medicine, etc. So the federal government, the United States government, has very little to do with the regulation of the practice of law in the United States, except insofar as lawyers want to go into the federal courts. And I'll explain this in a little bit more detail as we go along. In my own state, for example, New York State, the court system regulates the practice of law. So when I graduated from law school, I had to take what's called a bar exam. And I had to pass this exam, and then once I passed this exam, I had to pass a character and fitness test. I was interviewed by what we call a character and fitness committee. I had to present to that committee affidavits from people who knew me in various walks of life, including at least one attorney. And these affidavits were to attest to my good character, because I had to be of good character in order to get admitted to the practice of law. And that, as I said, is a state function. The court system is the body in New York State that regulates the practice of law. It's not the Bar Association, not in New York State. In certain states in the U.S., there is a bar association that is called a compulsory bar. And lawyers are admitted to that compulsory bar, and that bar will then regulate their conduct. In many of those states, there is also what is called a voluntary bar association. And that voluntary bar has nothing whatsoever to do with the admission or the regulation of lawyers to the practice of law. What it does do is allow those lawyers to gather in groups, to provide education to each other, to provide lobbying strength, and by lobbying I mean advocating for legislation, for example. It allows them to also do such things as meet each other, and that's very important, as we all know, in terms of developing solidarity within the profession, as well as finding opportunities for business by referring work to each other. In New York State, we do not have one of these compulsory bars, but we do have multiple bar associations. Each of our 62 counties in New York State has its own bar association, and as I said, these are voluntary organizations. Lawyers gather there for professional education and for social opportunities. We have citywide bar associations. For example, in New York City, we have a New York City Bar Association, and we also have the organization of which I was president about 10 years ago, the New York State Bar Association, which is the largest. It has approximately 75,000 members, and these are people who choose to belong to this association for the various purposes that I've described to you. Now, alongside these organizations, we have the court system, which, as I mentioned, is how lawyers get admitted. And the court system is what disciplines lawyers. The court system also is a group or the organization which has told us lawyers that we must have continuing legal education. Until continuing legal education was made mandatory, there was no such obligation in New York State. Other states still have no mandatory continuing legal education. In those states, it's up to the lawyers to decide whether they want to continue their education. Many of us, prior to it being made mandatory, just felt it was our obligation to our clients and to ourselves to continue the study of law even after we'd left law school, to stay current and also to improve our skills. So this can be a source of confusion for many people, the variety of organizations that we have. Now, in addition to the states regulating lawyers, we have a federal system. We have federal courts throughout the country. The top court in New York State is the U.S. Supreme Court, which sits in Washington, D.C. Now, under the U.S. Supreme Court, we have 12 circuit courts of appeals, various districts across the country, plus another one for the District of Columbia. So we have 13 circuits in all. These courts hear appeals of federal issues from federal courts. Each of our states has one or more federal courts in them. In New York State, for example, we have 4 federal districts. And those districts have their own requirements for lawyers who practice before them. I, for example, am admitted to practice law in New York State, so I'm permitted to go into any court in New York State to practice law, except any federal court. In order for me to go into a federal court, I have to get admitted. So I am admitted to the 2 federal courts in New York City. We have the Southern District there, and we have the Eastern District. I'm admitted. We have another system. It's very confusing to be an American lawyer. We have patent and trademark lawyers, and they practice before the U.S. Patent Court and Trademark Courts, which are in Washington, D.C. They have to be admitted as lawyers in a state or in Washington, D.C., general admission. Then in addition to that, they have to get admitted to the Patent and Trademark Court. I could not go and handle a case in Patent and Trademark Court because I'm not admitted. Finally, we have tax courts. I shouldn't say finally. It's not really final yet. We have tax courts. And in order to practice in those tax courts, you have to get admitted into the tax courts. Then we have courts that deal with issues like espionage because of the terrorism. So we have specialized courts that deal with those issues, and we have specialized courts of appeal to deal with people who have been convicted of terrorism. So it's a very, very confusing situation that we have for lawyers. However, one thing we all have in common is the obligation to be zealous and faithful advocates for our clients. We have a unique obligation as lawyers. We are to put the interests of our clients before everything else in our lives, including our friends, our families, our religion. Our clients and our duty of loyalty to our clients, that is our paramount. Those are our paramount responsibilities. And that's one of the unique qualities and one of the unique burdens of our profession. And it's why we as lawyers take so seriously this issue of multidisciplinary practice. And I'm not here to advise you what you as Portuguese lawyers, judges, legislators should do. That would be presumptuous of me. But I am going to tell you a bit about the history of multidisciplinary multidisciplinary practice in the U.S. and probably with a greater emphasis on New York State. Now, this is an issue with which I have been involved for about 15 years now. And I'm going to take you back and give you a little bit of history. So now I'm going to go to my prepared remarks. As I say, I will describe the history of alternative business structures, which is what we call the structures which would be practicing in a multidisciplinary environment. And I'm going to talk to you about what has happened at the American Bar Association and the New York Bar. Now, you've heard some mention of the American Bar Association before. This, again, is a voluntary association. It is open primarily to American lawyers, though there are lawyers from other jurisdictions who are admitted as affiliate members. For example, a Portuguese lawyer might choose to join the American or the New York Bar Association in a special category. So, multidisciplinary practice, as I mentioned, first really surfaced in the late 90s, and it came about because accounting firms were getting into that practice. And so we in New York State decided that we needed to take a look at it, and the American Bar Association decided we ought to take a look at it. And the American Bar Association created a commission called the CUTAC Commission. Oh, and one thing I forgot to mention, a side issue, is in Washington, D.C., which I mentioned is where our capital is located, there is such a thing as multidisciplinary law firms, because law firms in Washington, D.C., unlike any of the 50 states, are allowed to have non-lawyers as members of that firm. Now, those non-lawyers are not allowed to practice law. However, they are allowed to assist the lawyers within that firm in the practice of law, and they are allowed to share in the proceeds of that law firm. So as I mentioned, the American Bar Association first considered alternative business structures in the early 1980s. And this was done under the auspices of something referred to as the CUTAC Commission, which carefully considered the issue of lawyers partnering with non-lawyers. And it initially proposed that such partnerships should be permitted, should be approved by the American Bar Association. And there was a model rule of professional conduct that would have applied in this case. Now, this model rule, known as 5.4, which is entitled The Professional Independence of the Lawyer, is the place in the ABA model rules. Now, as I mentioned, the ABA has no regulatory authority, but it has developed these model rules, and these model rules have served as what they call themselves, models for the states. And most states have adopted these rules. They may have modified them slightly, but they've adopted these basic rules with the exception of California. California chose not to go along. So Model Rule 5.4, which is entitled Professional Independence of a Lawyer, is a place in the rules that specifically prohibits non-lawyers from having an ownership interest in a law firm. Now, you might ask, well, how can D.C. then have non-lawyers in law firms? But remember, I said the ABA has no legislative authority. It is a moral force, that's all. It can recommend, but it cannot enforce. So D.C. has chosen to ignore that rule. And Model Rule 5.4 also prohibits lawyers from sharing fees with non-lawyers. Now, back in that era in the 80s, when the CUTAC Commission came before the American Bar Association House of Delegates, the House of Delegates is the policy-making bar of the American Bar Association. It consists of about 575 people. This group gathers twice a year in the summer and in the winter, and it debates for a day or two policy issues for the American Bar Association. I am a member of the House of Delegates. I'm one of the representatives from New York State, and we debate various issues and pass resolutions. Those resolutions then are binding on the American Bar Association in terms of policy. They are not binding on any state or other jurisdiction. They're merely recommendations. So at this House of Delegates, there was a great deal of debate about this 5.4. And a question was raised, for example, would Sears Roebuck, I think your comparable company here might be Tesco, it was a large department store at the time, would Sears Roebuck be entitled to hold itself out as a law firm and practice law? And the answer was yes, under this proposal as it was then framed. And that proposal was then defeated. Now, moving into a later period of time, in the 1990s, there was this movement with accounting firms becoming consultants, and these firms continuing to expand what was considered to be accounting. And there was a thought at this time, well, let's revisit this multidisciplinary practice, because maybe lawyers should be encompassed in these accounting firms. And that, in fact, I think has happened to a certain extent here in Europe. For example, I think PricewaterhouseCoopers over in the UK does have lawyers who are practicing law there. Well, the ABA created a commission on the multidisciplinary practice, and that commission was to study and report on the extent to which and the manner, and this is a quote, in the manner in which professional service firms operated by accountants and others who are not lawyers are seeking to provide legal services to the public. So while accounting firms were the drivers behind this work of this commission, the commission also heard testimony and received comments from others that suggested that the model rules should be revised to permit multidisciplinary practices, and that such changes would benefit both lawyers and clients. While the ABA, remember the overall Voluntary Bar Association in the United States, was doing its work, my own association, the New York State Bar Association, created a special committee, and it was called the Committee on the Law Governing Firm Structure and Operations. And this special committee was chaired by a friend of mine by the name of Robert McCrate, who is a unique individual. He was the president not only of the New York State Bar Association, but at one time he was the president of the American Bar Association. And I was a member of that committee and helped write that report. And the report was entitled, Preserving the Core Values of the American Legal Profession, the Place of Multidisciplinary Practice in the Law Governing Lawyers. Now, unlike the conclusion of the ABA Multidisciplinary Practice Commission some years prior, which proposed, remember, changes to Model Rule 5.4 to permit MDPs, the McCrate report, the McCrate Commission, concluded that the prohibition on non-lawyer investment in and ownership of law firms should remain intact in New York. And this is key, because remember I said each state regulates its own lawyers. So regardless of what the American Bar Association was recommending, New York State was going to go its own route if the New York State Bar Association should prevail in its view. And this was advised by this McCrate Commission, quote, because the risk to professional independence and other core values was overwhelming. Now, that report was approved by the New York State Bar Association House of Delegates. The New York State Bar Association House of Delegates is akin to the American Bar Association House of Delegates. It's just for New York State. It's about half the size of the American Bar Association House of Delegates. And its objections, the New York State Bar Association, based on this recommendation, then was one of those groups that opposed the American Bar Association's proposal. So the ABA-MDP Commission's proposal to permit lawyer control, now this was a little variation. These MDPs were to be controlled by lawyers, not by the other entities which were practicing with the lawyers, but by the lawyers. But nonetheless, the American Bar Association rejected this proposal. And the House of Delegates adopted a resolution which provided that the sharing of legal fees with non-lawyers and the ownership and control of the practice of law by non-lawyers are inconsistent with the core values of the legal profession. The law governing lawyers that prohibits lawyers from sharing legal fees with non-lawyers and from directly or indirectly transferring to non-lawyers ownership or control over entities practicing law should not be revised. Now that ended that particular movement towards multidisciplinary practices. But those of you who are familiar with vampires, I'm sure there are vampires here still, right? Knows that we have to drive a stake through their hearts or they come back to life. Either that or we hold up a mirror to them. Maybe that will scare them. But no stake was driven through the heart of the American Bar Association House of Delegates. So in 2010, or in 2009 actually, there was a president of the American Bar Association called Carolyn Lamb. She's a partner in a firm called White & Case, a famous law firm in the United States. Started out in New York, but now they are a global firm with thousands of lawyers around the world. She appointed something called the ABA Ethics 2020 Commission. The ABA Ethics 2020 Commission was charged with examining the impact of globalization and technology on the legal profession and its ethics rules. The principles guiding the Commission's work were protection of the public. Remember, that's always key to us as lawyers. We've got to protect our clients. Preservation of core professional values, and maintenance of an independent, strong, and self-regulated profession. That is one of the unique things about us as lawyers. We have the ability to, in large part, engage in self-regulation, and that's a privilege that few are accorded. Now, this particular commission's preliminary issues outline invited consideration of how core principles, and that's important again, core principles of client and public protection can be satisfied while simultaneously permitting lawyers and law firms to participate on a level playing field in a global legal services marketplace that includes the increased use of one or more forms of alternative business structures. So the vampire got out of his coffin again. The Commission formed a working group to study the impact of domestic and international developments with regard to ABS, alternative business structures, in particular in Canada, Australia, and the UK. And I don't think I've mentioned that before, but those places all do allow multidisciplinary practices. It's interesting that all come out of that Anglo-Saxon heritage, and yet the US somehow has escaped. But Canada, Australia, and the UK are heavily into multidisciplinary practice. In the UK in particular, and this is part of the charge, there is a large population of US licensed lawyers, and implementation of the UK Legal Services Act was underway when Carolyn Lamb started this initiative. During its study of this issue, there were also changes afoot in Ireland and Scotland, again, the Anglo-Saxon tradition. As part of its work, the Commission looked carefully not only at the substance of the changes abroad that permitted forms of ABS, but the motivating factors behind those changes. For example, in the UK, certain changes to the regulation of the profession were made in response to consumer complaints and demands. So this was not an initiative that the lawyers or even the accountants were behind. But this was supposedly, and maybe I shouldn't say supposedly, but this was said to be a consumer protection issue. There was a desire to limit the monopoly that lawyers were said to have on the practice of law. This was supposed to be consumer friendly, and it was to create more competition for lawyers and to make legal services more readily available. Now, what does this mean? Does this mean the corporations need protection? No. This was not focusing on the larger law firms. This was focusing on smaller law firms, those law firms who cater to individual consumers rather than to business. We all know businesses can take care of themselves, but there was an alleged concern for the individual citizen. Now, there was, well, let me just go back a minute. As part of its work, the Commission looked carefully not only at the substance of changes abroad that permitted forms of ABS, but the motivating factors behind those changes, which we've just discussed. For example, in the UK, certain changes to the regulation of the profession were made in response to consumer complaints and demands. This was not present in the US. I don't know if it's present in Portugal. In many instances, change resulted from the involvement of the country's competition authorities. It did not come from within the profession that we just discussed. And this, again, is not a complaint people in the U.S. have. The only complaint that people, individuals in the U.S. have is that there are not enough lawyers who are affordable to them. It's not that there are not enough lawyers. We have a surplus of lawyers. But we also have a surplus of law students heavily indebted, because law school in the U.S. is not free and it's very expensive. And students typically borrow tremendous amounts. It's not unusual to have students come out of law school owing hundreds of thousands of dollars because they have borrowed for college and they have borrowed for law school. And they come out with these immense debts. And there are a lot of jobs that are available, let's say, in the not-for-profit area. But those jobs, when they were available, did not pay enough for the students to pay off this debt and to afford to get married and have a family. Now, maybe if both halves of the couple had finished law school and each of them was successful in obtaining employment, they could afford it. But many people cannot. So these jobs were going begging. Now, in addition, with the recession, which is worldwide, there is less money to pay for these not-for-profits. So there are many lawyers who would be happy now to take these low-paying jobs, either in the government service or in a not-for-profit serving the indigent. But funding for those groups has dried up. We know we now have sequestration in the United States, which means that our courts in the United States now have to cut back. Our federal courts are cutting back on the services because of the reception. Our state courts are underfunded. They can't stay open 5 days a week. So they may be closing on Fridays, for example. People are being furloughed, laid off. So there are plenty of lawyers graduating. There are plenty of legal needs to be met, but there is not enough money to pay for those legal needs. Returning to the Ethics 2020 Commission, it engaged in significant outreach regarding the subject of multidisciplinary practice. It released issues papers, held public hearings, invited input from the profession and the public. The Commission reached out to consumer groups that during the time of the NDP Commission had expressed great interest in change that would allow alternative business practices. But then the Commission found that, in fact, these groups did not come forward and support MDP. The Commission actually received very few comments saying that we need MDP because it will give us greater access to legal services. So in June of 2011, the Commission made its first decisions on the subject. the Commission decided that it would not recommend some forms of non-lawyer ownership that other countries permit. Specifically, the Commission did not recommend multidisciplinary practices. It did not recommend publicly traded law firms. That means law firms that can be listed on a stock exchange and traded like General Motors or Tesco, for example, which is permitted in Australia and is now permitted in the UK as well. Or passive outside non-lawyer investment, not shares necessarily, but just your friend has a law firm and needs some capital to expand her office, and you decide to provide, not as a loan, but an investment of $100,000 in return for a share of the profits. The Commission continued to study a more restrictive form of non-lawyer partnership and ownership in firms than that allowed in Washington, D.C. Remember, that's the only U.S. jurisdiction where this practice is allowed. Unlike the D.C. rule, this contemplated model would set forth restrictions on the percentage of non-lawyer ownership and control via voting rights. The Commission again sought comments on this possible change and took testimony on it. Now, around this time, the president of the New York State Bar Association appointed a task force of non-lawyer ownership to consider the work of the ABA Commission. And the president at that time recognized that 10 years had passed since the issue last was discussed by the Bar Association. And it set itself a deadline of September of 2012, of last year, so that it would complete its work in time for the Ethics 2020 Commission of the ABA to have the information that the State Bar had developed when the ABA came with its final report to the House of Delegates. Now, in April of 2012, in the meantime, however, Ethics 2020, remember, that's the ABA Commission Carolyn Lamb appointed, they decided not to propose any changes to Model Rule 5.4. And Model Rule 5.4 is the one that talks about the possibility of interdisciplinary practice. The Commission, and this is the ABA Commission, found that at this time there was not a sufficient basis for recommending such changes. That means there was not pressure from the public or even from the profession to bring about these changes. The ABA went on to say the case had not yet been made, but that it would continue to study the issue of how, given the multi-jurisdictional nature of law practice, to provide guidance on the choice of issues relating to ABS. Now, by the multi-jurisdiction of practice, for example, my law firm has an office in Washington, D.C., where multidisciplinary practice is allowed. All of our other offices are in jurisdiction where they're not allowed. How do we handle finances within the firm so that we are not sharing fees with non-lawyers, because we're prohibited from doing that in every other jurisdiction? So what we have done is we have a separate consulting firm in D.C. that does consulting work. They have their own compensation structure. They don't benefit from what we do, but this provides clients with one-stop service, this separate firm in D.C. And they have no connection to us in the New York firm. We don't intermingle expenses or profits. And to return to my text, so it says the choice of law issues focused on the division of fees between lawyers not in the same firm. This is one category. It's called interfirm fee sharing. I was just talking about intra-firm, with one lawyer being in a firm that is an ABS and the other lawyer being in a firm in a place that prohibits them. The Commission considered amending the model rules to permit such fee divisions. Ultimately, however, the Commission decided that an ethics opinion would better address these concerns. So I'm going to use a football analogy here, and not football as it's known in Europe, but football as it's known in the US. And the Commission decided to punt. You know, a punt means you can't run another offensive play because you're in an unfavorable position on the field, so you kick the ball downfield to move it to the other side of the midfield. So what the commission did was they sent a question to a committee at the American Bar Association called the Ethics Committee and asked them to study the issue some more and come back with a report because the commission had a deadline by which its report was due. Now, returning to the New York State Bar Association and its task force, now its task force report was approved by the New York State Bar Association House of Delegates last November. And that report affirmed the New York State Bar Association's opposition to non-lawyer ownership of law firms, absent better and stronger evidence that it was in the best interest of clients and will not undermine the integrity of the profession. So the focus has remained on clients, as we as lawyers have to put the interests of our clients before our own interests. So like the Ethics 2020 Commission, that's the ABA Commission, the New York State Bar Association found an absence of evidence supporting the need for such change at this time. Both the Commission and the New York State Bar Association recognize that alternative business structures should continue to be studied and analyzed. Nobody's saying forever that these things should be forbidden. In particular, it was said, it will be interesting to see if and how alternative business structures in the UK fulfill the promise to lower the cost of legal services and increase access to justice. Now, there are some other developments going on, and I'll tell you about a couple of them quickly. In 3 states in the United States, New Jersey, New York, and Connecticut, which are in the Northeast, there is a law firm called Jacoby and Myers, and that law firm has filed suits to have Rule 5.4's prohibitions on alternative business structures declared unconstitutional because it has said that rule violates the First and 14th Amendments to the United States Constitution. Now, in the New York case, the court system, remember I said in New York the courts regulate the practice of law. The court system was the defendant in that case, and it moved to dismiss the case on the grounds that the law firm of Jacoby and Myers had no standing to bring the case, and succeeded at the district court level. However, the Court of Appeals said the dismissal was improper, reversed it, and the case was returned to the district court to allow the law firm to amend its complaint to name the proper defendants and to challenge various provisions of New York law that prohibit investment by non-lawyers and law firms. In addition, that litigation is pending in New Jersey and Connecticut, so it will be interesting to see what happens with that litigation. And let me explain another complicating factor about U.S. law. Remember, I mentioned at the beginning we have 13 federal circuits. Well, what we can have happen in the U.S. is one federal circuit, such as the one that governs New York, the Second Circuit, could decide one way on this case. That governs New York and Connecticut. And remember I said the other case is pending in New Jersey? That's in a different circuit. That's in the Third Circuit. That case could be decided in an entirely different way in the Third Circuit. And people who live in the Third Circuit, New Jersey, Pennsylvania, Delaware, Maryland, so on, law firms would be governed by the law of the Third Circuit. People who live in New York, Connecticut, Vermont, be governed by the law of the Second Circuit. So one circuit, maybe you could have multidisciplinary practice because of the Constitution. The other you could not. So what you have to do in the U.S. then is we have to file a petition with the United States Supreme Court and say there is a conflict between the circuits. I have a law firm that practices in both those circuits, or I have an accounting firm that practices in both of those circuits, and I don't know what to do. We need the U.S. Supreme Court to intervene and make a decision. So that conceivably could happen at some point, in which case I'll be back here in 2 or 3 years to tell you what happened. Now, predating this litigation, there was a law proposed in North Carolina. That's in another circuit, that's in the Fourth Circuit, to allow non-lawyer equity owners of incorporated law firms. While that law never made it out of its committee, in our legislature, things typically go to a committee first, and if the committee approves them, then they go to the overall legislation. That happens both the state and the federal level. But there are other changes that are occurring in the U.S., and I'll just mention one, a company called ClearSpire. It's a new business, and this is how it markets itself. I'm quoting now. Led by a team of proven innovators from legal practice, business management, and information technology, ClearSpire has transformed the way legal services are delivered. Our unique structure enables attorneys to focus on practicing law while seasoned business leaders manage the infrastructure and delivery of legal services. Connecting the two, ClearSpire's IT platform provides some of the industry's most advanced technologies and IT methodologies, enabling our lawyers to work more closely with clients and with each other while simultaneously streamlining the management of business. Continuing with the quote, in this way, ClearSpire merges the best of legal and business practices. Clients receive the highest quality results produced by AmLaw 200. AmLaw is a publishing company, American Lawyers Media. And AmLaw produces a survey each year that ranks law firms in the U.S. on profitability, on revenues, also on firm size in terms of number of lawyers. So the AmLaw 200 would be the 200 largest law firms in terms of revenue in the U.S. And by being in that category, they probably hire the best law students to come to work for them. So that's why they're talking about AmLaw 200 trained. So they're saying they are hiring high-quality lawyers. AmLaw trained senior-level attorneys, often for about half the cost of an AmLaw 200 firm. And remember, I said it's profitability. So if the firm is the most profitable, it probably has the highest rates. So they're saying that their rates are much lower. You're getting the same quality lawyers you'd get from one of these big law firms, but you're getting them at half what the big law firm would charge you for their services. The end result, a multidisciplinary practice, including full management and legal responsibility, that is competitive with the best of big law, a pseudonym for the AmLaw 200, delivered with unprecedented efficiency. That's the end of the quote. Now, the question is this a violation of Rule 5.4? I don't know. First, ClearSpire is based in Washington. Remember I said Washington allows for multidisciplinary practices. But I don't know enough about the structure of ClearSpire. There has not been litigation yet. And I will mention, in terms of there being no litigation yet, there may be some later, because I'll read you something else. This is a press release ClearSpire released 2 months ago. ClearSpire Service Company is pleased to announce the nationwide expansion of its physical presence in response to positive market reception and growth since the 2010 launch of its law firm, beginning with the 2013 opening of offices in New York City, Los Angeles, and the San Francisco area, in addition to its existing Washington, D.C. headquarters. ClearSpire plans to open offices across the U.S. and increase its roster of attorneys by 50 to 100 annually to keep pace with market demand. In addition, future offices are planned for Atlanta, Georgia, and Chicago, Illinois. There is also something called Legal Force, a book flip store, but I've gone on enough, I think. And at this point, all I can say is in New York State, the Bar Association has concluded that there is no present need for multidisciplinary practices. Consumers are not asking for it. and there is no pressure among most law firms to develop it. Now, the issue we all have to face is, what do we do with all these law students who have graduated and have passed the bar and can't find employment? We have to find a way to place them. I don't know if we will be able to do that until the recession ends, but let's hope that we can. Thank you very much for inviting me here.